G'day, I'm Stephen Page from Page Probe Family and Fertility Lawyers, and you're watching and listening to the Australian Family and Fertility Law Podcast. What I'm talking today about is two cases that illustrate the point that it's important when you're doing surrogacy work that you hire a lawyer who knows what they're doing. And just don't accept their word that they know what they're doing. Actually look into them and check them out. Now in my case, I'm not only a dad through surrogacy, but I've advised in over 2,000 surrogacy journeys, more than any other lawyer in the country. And the first of those was way back in 1988, probably before you were born. So after I've just aged myself, I just want to talk about these two cases. The first case was a case called Re-N, and it was a case in the Supreme Court of New South Wales, so domestic surrogacy. The screw up in this case was that after the child is born in New South Wales, the New South Wales Surrogacy Act says you've got to do two types of counselling, or have involvement with two types of counsellors. One is that the surrogate, and if she's got a partner, her partner, get relinquishment counselling. And the second is quite different, an independent assessment report as the best interests of the child. Now, for some reason, the experienced counsellor did both on the same day. And you go, how could they have done that? You would have thought that the lawyer who was acting for the intended parents, an accredited family law specialist, would have looked at the act, would have realised that this was a problem. Well, the judge realised there was a problem. He called the matter on and said, look, there's a problem. The counsellor can't have done both of these. So there's got to be a change. There's got to be someone else doing the independent assessment report. That would have fixed it. How was the fix then sought to be done? Well, he'd done the independent assessment report, so it was thought, well, get someone else to do the relinquishment counselling. Well, it's no surprise that when it came back before the judge said, it's not independent. The counsellor, this experienced counsellor, has done relinquishment counselling on the same day as doing this report, so it's not independent. The lawyer then tried to argue, well, there are special circumstances, which included, I suspect, that the cost of the counsellor at this point to the lawyer's clients was about $4,000. Answer, the judge, no, it's not compliant. You've got to go off and get a report. I'm not making the order. So it's really an illustration that if you had a lawyer who was on top of this, knew this intimately, that wouldn't have arisen in the first place. The second was the case that I've talked about in other videos, but I'm going to talk about again. The couple from Brisbane who went to North Cyprus for surrogacy, Lloyd and Compton. And this case, they ended up in the family court. They had a lawyer from Sydney act on their behalf. They were going to the family court here because the wife was not shown on the birth certificate as a parent. And the obvious fix to that is to get a step-parent adoption, which then requires, in Queensland at least, to get leave of the family court to do that step-parent adoption. Well, some thinking should have gone into that exercise, because what happened? The judge noted that on the face of it, the lawyer had said there was commercial surrogacy, and therefore, on the face of it, offences had been committed. And as a result, referred the couple to the Director of Prosecutions for investigation as to whether they had entered into a commercial surrogacy arrangement on their own admission, after they had filed their material, after their lawyer had said it was commercial surrogacy. And the lawyer referred to the New South Wales Legal Services Commission for procuring and filing an affidavits about commercial surrogacy, an offence, and I think most cuttingly, for competence. And it's clear when you read the judgment that the judge criticised the lawyer for not coming up with the goods, and the lawyer should have done so. So both those cases illustrate the point. If you are undertaking surrogacy, which is a complex area, go to a lawyer who knows what they're doing. The lawyer in Lloyd and Compton was also an accredited family law specialist, but clearly knew certainly not enough about surrogacy, or would not have got their clients and themselves into that mess. Thanks for watching and listening. I'm Stephen Page from Page Provan Family and Fertility Lawyers, and this is the Australian Family and Fertility Law Podcast.